Okay, this is video 16, February 27th, 2026. We're beginning lesson 6 on penal law, and it's divided into 4 parts. In this video, I hope will cover the first part, 6A. And this is going to be an overview of kind of canon law, but especially the state of canon law, sort of since Vatican II, kind of to the present, but especially up to Pope Francis's reform in 2021, focusing on how penal law in particular changed from the 1917 code to the 1983 code, and why a reform was necessary. Okay, so we'll be doing a few things. A few principles of penal law. Again, some review of what's happened since Vatican II. Some of the characteristics of the 83 code. The huge shadow of the clerical sexual abuse scandal really hangs, you could say, hangs over the U.S. church or the church generally, but this is especially true of the field of penal law. And then touch on some of the key themes in penal law and at least a few of the key features of the reform. Okay, let's begin with some background. Canon 1311 tells us that the church has the inherent right to coerce the faithful who commit offenses. I'll show you this in my notes. There, the inherent right to coerce the faithful who commit offenses. And we will see this language of inherent right in other places too. At least one or two others. One of them will be when we get to the church's patrimonial law, the church's property law, and it will be about the church's inherent right to acquire the goods that it needs to fulfill her mission. Despite this key principle about the church's inherent right, in the time after Vatican II, there were some people who wanted to abolish penal law altogether. Remember lesson 1 in our class, we talked about antinomianism and how it comes and goes in the church at different times. You could say the time after Vatican II was one of the times that there was an antinomian spirit about. The idea of completely eliminating penal law did not succeed. However, you could say that penal law limped away from the fight, kind of like Jacob after he wrestles the angel. In the 1917 code, there had been 220 penal canons, and this was reduced to 89 penal canons in the 1983 code. That, I'm not going to say that number tells you everything. Here it is indicative of the decline in importance of of penal law. Much was left to the local bishops in the 1983 code. What else was characteristic of the original 1983 code? Many of the penalties were optional. That is, the law would list an offense or a crime, or what penal law calls a delict, D-E-L-I-C-T. That's just the canonical word for a crime. But then it would list this crime and would say it may be punished. This may be punished by such and such, and it might either specify what might be the penalty or it might not. So it would list a crime, but say it may be punished, not it must be punished. That was something that Pope Francis would see as a weakness. Saying, well, if it's a crime, it should be punished, not it might be or might not be. What else? Some of the penalties, if they weren't optional, they were indeterminate. So they might say, well, if you do this, if you forge an ecclesiastical document, you will be punished with a just penalty. There, the penalty is not optional. It's saying you will be punished, but it doesn't say what the penalty is. It just says a just penalty, which is very, very open-ended. Those are some things that Francis will, years later, want to have corrected or want to have specified, want to have made more concrete in his 2021 reform of the law. The other thing is, or one other thing, there was a canon in the original 1983 code. Now the canon numbers in the penal section have changed a fair amount, but there was a canon there, 1341, and it specified all these different things that should take place before a penal process began, that there should be all these attempts at outreach towards the offender. And this canon, and you can see the reason for that. Yeah, if we can solve something more easily, why don't we do that? And on one level, that really makes sense. But on another level, it went so far in that direction that it seemed to say that actually using the penal process was an absolute last resort. That's one of the things Francis will say in, I believe he says it in Paschae Gragium, that the penal law needs to be acknowledged as a normal part of church life. And what happened following the establishment of the 83 Code was that it fell away in that sense. I shouldn't say fell away, because I don't think it was used much or from the time of Vatican II afterwards either. That period, though, was probably more understandable because we had the council and everybody knew that the code was being, we would have a new code in light of the council. So what happens? The 1983 code takes effect at the very end of 1983, in fact, at the end of November, so just almost 1984 by this time. What happens about a year later? What happens is the sexual abuse crisis erupts. Now, this might be somewhat surprising to you, so I'm suggesting to you, well, you might think of the sexual abuse crisis as erupting in 2018, because if you were paying attention to church events then, you'll remember, especially that summer, the McCarrick scandal blew up, and also the Pennsylvania grand jury report. If you're not familiar with those things, you can look them up, but they were just huge news in 2018. However, you could go back even further. You may have heard of the Dallas Charter and the Dallas Norms. Those came out of the bishops' meeting in Dallas in 2002, and they were based especially on revelations of the mismanagement of sexual abuse cases, especially in Boston, also in Los Angeles, though. At other places too, you started to hear about these cases throughout the country, but focus really was on Boston, and my sense is that Los Angeles was just as bad. Probably did not get quite as much attention as Boston, though. However, despite these two landmark years, landmark for the life of the church in a bad way, but there certainly were landmark years, 2018 and 2002, you could go back even further and peg the year 1985 as a key year in the abuse crisis, maybe the key year, because then we get our first two widely known cases of abuse by Catholic priests. One arises in the Diocese of Lafayette, Louisiana, a priest named Gilbert Goffey, and soon after that, another arises in the Diocese of Fall River, Massachusetts, concerning a priest named James Porter. So this arises very soon after the 83 code it comes to light. It's not so much arising, because when it comes to light, as you probably know about these cases, they're looking back usually a number of years, even decades sometimes. So it's not that the abuse necessarily was taking place in 1985, though it may have, but usually it's something that took place long before, or that's been going on for quite a long time. So a lot of past and ongoing abuse is revealed. How had church leaders... This turns out not to be only true of the U.S., but the real focus is on the U.S., and often the crisis is identified with the U.S. That's fair and not fair. It certainly happened in many other places too. However, it did come up first in the U.S., and then there's just a lot of attention, a lot of news stories that went into it. So how did church leaders deal with it? And we're talking basically of the time in the 60s, 70s, and 80s, maybe even going back into the 50s. They dealt with abuse, and again, we're talking about abuse of children or of teens. They dealt with it as a matter of sin or a pastoral matter, basically looking at it in a therapeutic way, but not really legally or canonically, not really applying legal or canonical penalties. Though both the 1917 code and the 1983 code made this a crime. So although this was a crime for this whole period, very few people were actually accused of it and tried for these crimes in the church. The two canons, if you're interested in looking at them, in the 1983 code 1395 and in the 1917 code 2359, those are the canons criminalizing this delict, sexual abuse of a minor by a cleric. In the documents that you're reading for the beginning of this lesson, you'll see the name of Archbishop Iannone at the Council for Legislative Texts, now the Dicastery for Legislative Texts. And he says, this is, I believe, in the press conference unveiling the new penal law. He says that during this period, the relationship between justice and mercy was misunderstood. And then another official, the secretary at the Dicastery for Legislative Texts, Bishop Arieta, he was another of my professors when I was studying canon law. He said, and now he's a bishop and he's secretary of legislative texts. He says, in the years immediately following the promulgation of the 1983 code, it became apparent that the penal discipline did not meet the expectations it had raised. And he notes that this was especially noticed by Cardinal Ratzinger, then prefect, and to become longtime prefect of the Congregation for the Doctrine of the Faith. Ratzinger responded by issuing a document in 2001 called, all you need to know is SS T. S as in Sam, S as in Sam, T as in Tom. The Latin name is Sacramentorum Sanctitatis Tutela. It was issued in 2001, but it was revised 2 further times later on. And this document said that the most serious crimes, and these would be offenses against the sacraments plus the crime of sexual abuse of a minor by a cleric, that these were going to be reserved to the CDF, the Congregation for the Doctrine of the Faith, Cardinal Ratzinger's office. And again, there were 7 specific crimes were specified. 6 were crimes against the sacraments, and 1 was the sexual abuse of minors. Okay, I think this is a good entry point to the essay that I gave, the 2019 essay by Cardinal Ratzinger, later Pope Benedict XVI, later still Pope Emeritus Benedict, during the first part and the majority of Pope Francis's reign. And so Pope Benedict wrote an essay in 2019 called "The Church and the Scandal of Sexual Abuse." And I hope you find this as thought-provoking as I do. This is I think, very valuable, because you have really one of the church's great minds reflecting on one of the church's great tragedies. Not only that, though, but it's someone who really was involved with trying to remedy things. People also have looked back in the earlier part of Cardinal Ratzinger's tenure and found fault with what he did, and saying that he did not act quickly enough. And there's a case to be made there. However, later on, he really became, and even at the expense of having to go through disagreements and battles with other cardinals, insisting on having these matters processed and tried according to law. So this is just one of these, it's a relatively long essay, but I think really, really worth your time. And I hope you'll really give it some time for you to. I think it'll really spur some thought and even prayer in your reading. I would ask you to note the great clarity of Ratzinger's writing. He's not always easy to read, but he's clear. If you give him enough time, he will get through to you. He's very sophisticated, but he's also very clear. What do we take away? Well, there are no easy solutions that he gives us. However, by the same token, neither does he give in to hopelessness. What does he say is the cause of the clerical sexual abuse crisis? And he gives his answer, and I think it just falls on us like a load of bricks, in the sense that I think it strikes us as something we can't get away from. It just, once he says it, I think, again, I'm just giving you my opinion, I think that it rings so true. You just have to say, yes, he's isolated this. What does he say was the cause? He says, the disappearance of faith in God. The disappearance of faith in God. Why did we have this horrible crisis going on for a very long time, and then not dealt with well by the leaders of the church, by and large? The reason is the disappearance of faith in God. He talks about unprecedented social upheaval, and especially the utter collapse of all standards of sexual morality between 1960 and 1980. And I think I think he's just clearly correct about this. And we kind of fool ourselves if we think that we are immune to these social pressures and they won't have any effect on us as individuals or as a society. He says, and this may surprise you, because you may not remember this time at all, probably won't. He says, it was not that long ago that pedophilia actually was promoted, and he is correct. He is correct about that. There actually was a well-known organization that it had this idea in the name of the organization, that this was it was to promote love between men and boys. It was in the name of the group. It was actually in the name of the organization. It sounds incredible, but he's not an exaggerator. What else happens? Not just the collapse of standards of sexual morality, but as he says, we are not going to be immune from this. What happens to us? The collapse of moral theology, the rejection of absolutes. Now, this is something that John Paul deals with in his landmark 1993 encyclical on moral theology, Veritatis Splendor. And you've probably read that with Dr. Schemenauer or heard about it in any event. In the church, again, the country that is discussed the most is the U.S., but we're definitely not the only one. The longer this went on, the more other countries arose where that had their own cases. Cardinal Ratzinger also referred to the corruption of seminaries and bishops in the U.S. And the U.S. bishops, actually, when they really came around to truly focus on this matter, they came to see the 83 Code as insufficient. And said, maybe we didn't apply this as we should have, but look at the code. It's very difficult to apply, basically because there are a lot of defenses that the accused would have in the 1983 Code, so it could be very difficult to either to prove something or to hold somebody fully responsible for an act. And for a long time, Rome rejected this view, but eventually they came more around to it, to agree with the American bishops that essentially there needed to be the penal law needed to be made more easy to apply. Ratzinger, we're still in Ratzinger's essay. What do we do? He says the problem we face is a society without God. I mean, especially, he says, in the West in particular, God is absent from the public sphere. How did pedophilia spread? Pedophilia and also ephebophilia. Pedophilia are essentially children. Ephebophilia is abuse of teens. They might not be children, but they're teens. They're not adults either. He says because of the absence of God. Why did we find ourselves in this crisis? Because of the absence of God. And he says even priests don't talk about God. So even priests are talking about other things and not so much about God. And he says at the very end, we must learn once again to live by God and to live unto Him and by Him. And in the same, when he's giving his diagnosis, he mentions the Eucharist as well and talks about the loss of reverence and the sense of mystery. Again, a very bracing thing to read. However, I don't think as much as he's facing up to something very unpleasant and um, very tragic. I don't think that we would say he's giving in to hopelessness. I think he's telling us what we need to do. And it's so simple. It's simple. Simple does not mean easy, though, right? Uh, Simple to know, simple to understand, maybe hard to do, though. What is it? To live by God and unto Him. Okay, that's the end of our first kind of mini part of Lesson 6A. Our next part, we're going to talk about some key themes in penal law. As we get into our study, we're certainly going to be concerned with protecting the vulnerable. That's really what the crisis is about, and punishing abusers. However, we also need to be equally concerned with fair treatment of the accused. So try to keep that in mind too. We've had both things in the crisis. The ones that people think about the most probably are the treatment of the victims, very understandably. However, when the pendulum swings the other way towards doing something, sometimes the reaction is excessive in some ways, and there's a movement to penalize the accused, maybe even without providing sufficient safeguards to him. Okay, let me tell you about something that we may address. There are two ways that a penalty kind of can be inflicted, or two processes or procedures. One is a judicial process where you'd have a judge and a tribunal, and the other is an administrative procedure where essentially the bishop himself would decide the case. The judicial process is one that has more safeguards for the accused, but it also takes longer to apply. Whereas the administrative procedure, where the bishop either runs the procedure, or it's run under his auspices, that is easier to apply. However, it has fewer safeguards for the accused. That's just one kind of issue to be aware of in dealing with penal law. Put that aside for now, but don't forget about it. Okay. Another important issue in penal law is how penalties come about, and we're right now going to focus on two particular ways. One way is called late sententiae, and you may have seen this phrase. And late sententiae, when a penalty comes about late sententiae, that means by the doing of the act, you immediately incur the penalty. So sometimes late sententiae is referred to as a penalty that is automatic, that you immediately incur the penalty by the doing of the act. One example is the delict of abortion. You have an abortion, or you perform an abortion if you're an abortionist doctor. By doing that abortion or having the abortion, you automatically incur the penalty of excommunication. Put an asterisk there now, because there's going to be some exceptions, but essentially, it's not that you've been put on trial. You've by doing the act, you've incurred the penalty. These penalties, applying a penalty, late sententiae. Why do we do that? Why do we say that? If this is something we want to punish, why don't we just notify them that they're being accused and then give them their day in court? The main reason is that these are crimes that otherwise might not be punished at all. For instance, how would the abortion come to the notice of the church? You might have no way of knowing it, and it's especially because in most Western countries, anyway, it's not probably all Western countries, it's not a crime any longer. It used to be a crime. It's not any longer. So these are things that might go unpunished. Why are late sententiae penalties controversial? Because they're being applied in a way without a process or procedure. Later on, there will be sort of something where, when it comes to the attention of church authority, they may declare, but they declare that you have incurred this penalty, late sententiae. The accused may not know that he or she is under a penalty. In that case, kind of the mechanism of having this type of penalty leads to some uncertainty. There are several factors. Remember the factors we said that the U.S. Bishop said, boy, there's all of these excusing factors that take away responsibility, and they make it harder to apply penalties. That can be true of late sententiae penalties too. So, for example, if you're too young, if you're a minor, or let's say you're under, for these purposes, a minor would be under 16, and you have an abortion. If you're that young, you do not incur the penalty. Or if you do not know that this is a crime, or this is a crime punished with excommunication, you would not be punished with excommunication. So this makes it, you've got on the one hand saying, well, you do it, you're excommunicated, but on the other hand, you've got these excusing factors that we're going to have to look at to say, did you really incur this penalty? So that's probably all we'll say for right now about late sententiae excommunication. What would the opposite of late sententiae be? The opposite would be ferende sententiae. Ferende sententiae. And that simply means more like what you think of as a trial, or a procedure, at least, that there's actually been a tribunal that met and that you had a chance to appear before, and you had a chance to have a lawyer, and then a decision was reached, and you were found either to have committed this crime or not to have committed it. Or if it wasn't before a tribunal, that would be the judicial process. There was some other type of procedure that took place before the bishop, but you at least had some opportunity to defend yourself. That would be ferende sententiae, more of what you think of as a kind of a typical trial for a crime. Okay, we need to say a little bit about types of penalties. There are two main types of penalties. Now, when we said late sententiae and ferende sententiae, those are ways that a penalty comes about. Again, either after a process or procedure in the case of ferende sententiae, or more or less automatically in the case of late sententiae. But as for the actual types of penalties, what's the penalty going to be? Okay, you're guilty of this. What are we going to sentence you to? There are two types of two main types of penalties. The first is called expiatory. That roughly means that the main purpose of the penalty is to restore justice and to punish. The other type of penalty is called medicinal. And medicinal penalties also are called censures. Now, the medicinal penalties are the most serious ones, but medicinal means that these penalties are actually primarily they too are meant to punish and to restore justice, but they're called medicinal because their main purpose is to recall you, to reform the offender, to recall you to good standing with the church. So these penalties, medicinal or also known as censures, there are three specific penalties that you could suffer if you've done one of the crimes. For instance, we've already said abortion is one crime that's punished with excommunication. What's another serious crime? Say desecrating the Eucharist. That would be something that would also be punished with excommunication. Okay, there's three types of censures. There are three different censures: excommunication, interdict, and suspension. So we'll just say a little bit about them. It's actually easier to start. Excommunication is the most serious, but it's actually easier to start with interdict. Interdict essentially means that you cannot celebrate, if you're a priest, you cannot celebrate the Eucharist or other sacraments, and you're either, as you're a priest or a member of the laity, you cannot receive the sacraments. That essentially is what interdict is. Yeah, and you can't really take any part in the sacramental ceremonies. Excommunication is similar. It starts with those two things. You can't celebrate the sacraments, you can't receive the sacraments, and you can't have any part in the ceremonies. But excommunication goes further because it also says that you cannot exercise any ecclesiastical office. For instance, if you're a pastor, you can't exercise your office, and you can't exercise any acts of governance. For instance, officiating at a marriage. So both interdict and excommunication have to do with the sacraments and not receiving and not celebrating the sacraments. But excommunication, in addition, refers to adding some things that have to do with church governance and your use of your office and exercise of your office or ministry, which you're also forbidden to do. In the Eastern Church, the terminology is a little different. Interdict is called minor excommunication, and what we call excommunication is called major excommunication. I kind of like that terminology because it sort of shows that there's a lot in common, but the major excommunication has some additional features. What's the last? Censure or medicinal penalty? Suspension. What suspension is that it forbids you to exercise, if you're a priest, your orders, either some aspects of your orders or all of them, or your acts of governance, or the rights of your office. It used to be that this penalty applied only to clergy. Now, with Pope Francis's reform, it also can be applied to the laity if they hold an office or something like that. But again, it's a little bit confusing because the word suspension itself doesn't tell you a lot, except that you it needs to be specified further what you're being forbidden to do. And I think of the serious crime, it's probably going to be any exercise of your orders or your office, etc. Let's go back to expiatory penalties. We've just talked about medicinal penalties, the most serious penalties. So what would be some examples of expiatory penalties? These would be some type of prohibition from doing something or some obligation. For example, living somewhere. You might be prohibited from living somewhere or obliged to live somewhere else. Um, Probably somewhere where the thought is that you won't be likely to recommit this crime. What would be other expiatory penalties? A fine, like actually paying a monetary fine. This too is new in Pope Francis's reform. There used to be no provision for receiving a fine like we might do in secular law, but now we do have that. A fine is a possible penalty. What else? We might take your office away, strip you of whatever office you have, being rector or pastor, or strip away some right or privilege or faculty that you have, something like that. The most serious expiatory penalty is dismissal from the clerical state, being dismissed and from the clerical state and returned to the lay state. Expiatory penalties, we said that excommunication and interdict they can be incurred either late sententiae automatically or ferende sententiae after a process or procedure. Expiatory penalties really are always they always come about ferende sententiae after a judicial process or administrative procedure. We said when we distinguish those two penalties that expiatory penalties are especially aiming at restoring justice and maybe repairing scandal, whereas medicinal penalties are especially aimed at calling back the offender. These are kind of the three purposes or finalities of penal law. The whole purpose of the whole of penal law: restore justice, reform the offender, and repair scandal. Now, when we say that the medicinal penalty is especially aiming at number 2, reforming the offender, the others, 1 and 2, repairing justice, restoring justice, and repairing scandal, they also come into play. And the same with expiatory penalties, although expiatory penalties are especially trying to restore justice and even to punish the offender. Still, these other things, reforming the offender and repairing scandal, also are important. It's just a matter of what the emphasis is on in those two types of penalties. Okay, third and last part of this lesson 6A, the actual reform itself. To start with, all three of these principles figured importantly in Pope Francis's reform, and Francis actually cites them in his constitution, where he puts out the new law, the Constitution, which you read, or you're going to read, Pascite Gregem Dei. What are some features of his reform? There's more determinacy and less discretion in applying penalties. We talked about that already, these optional penalties or these indeterminate penalties. Those have been largely, maybe even completely remedied. So there are no optional penalties anymore. If there's a crime there's a punishment applied. And with the indeterminate penalties, there are still some that refer to a just penalty, but these are reduced. There's more definiteness in what the penalties are going to be. What else? And this came up the other day with Brother Chrysostom's questions about the penal law reform. One aspect of it is that this reform takes more account of lay persons. We just gave one instance, which was that suspension used to be a penalty that only a cleric could incur. Now, though, lay persons hold some offices in the church. They might be a judge, a chancellor, a financial administrator. So now suspension can affect lay persons too, and this is a good change. It reflects the reality we're actually living in. What else? The reform emphasizes financial crimes. There's a specific drive to detect and repair financial crimes, misappropriation of money, essentially. The organization is improved. We'll probably see this more or talk about this more when we go through the actual delicts and see how they're organized, the headings under which they're organized. And also, this is a kind of a good thing in light of the abuse crisis. There are some additional protections for the accused. Some people don't like latae sententiae penalties. A prominent canonist in this camp is Edward Peters, and he would have liked to see latae sententiae penalties eliminated, and that did not happen. So we still have latae sententiae penalties. What other a little bit more detail on some of the specific changes? I mentioned the rights of the accused. Some improvements here. One is that the presumption of innocence, which I think most people would say already was in the old code, but it was not as explicit as it could be. It's been made much more explicit, and you can find that in Canon 1321. Also, we have a clearer standard of proof, which is very important if you're being accused. How certain does the judge have to be to find me guilty? Does he have to say, well, it's a little bit more likely than not? That's not a whole lot of protection for you, because say if your witness is a little more believable than mine, but they're both pretty believable. If we're just weighing what's a little bit more, where does the weight of evidence come down on? Even that a small difference in the credibility of a witness on your side might really lead to my being convicted. But that's not the standard. That would be kind of a 51% or a preponderance of the evidence standard. The standard is much higher, fortunately, for the accused. And what the standard is moral certainty. So not just that, yeah, it's more likely than not. Yeah, it looks like he probably did it. No, it's more than that. It's enough that the judge or the bishop must have moral certainty, which is a much higher degree of certainty. It wasn't that the old code or the old penal law had the lower standard. It was just the standard itself was not made clear enough, and now it's been made clearer, and that's a good thing. Also, there's more of an emphasis on moving penal cases along. They can still take a long time, but there seems to be less likelihood now that an accused person, we're especially concerned about clerics, accused cleric will be out of ministry indefinitely and with nothing happening in his case. That's things like that. You hear a lot of accounts of stories like that. If you want to look at somebody who's written about some of those things, you could look at, and this would be before Francis's reform, but you could look at Cardinal Avery Dulles. He wrote some articles about this in his last years before he passed away. As we said, a new emphasis on the laity. We mentioned this in some ways. It's a crime to attack the Pope. It's a crime to attack a bishop, but up till now it was not a crime to attack a lay person. Now, if you attack a lay person out of hostility to the faith, you're attacking him because he's Catholic or because of his role in the church, that too is penalized. So here's another area where there's more account being taken of the laity. There are some new delicts and some that have been resurrected. We already said there's more emphasis on property crimes or patrimonial crimes. Also, now administering the sacraments to those prohibited from receiving them, that is a new delict. Attempting to ordain a woman, that was not in the 1983 code, but it was in that other document from CDF that I told you about, SST, but now it's actually in the code. And seminarians, perk up your ears. Presenting yourself for ordination when you are bound by a censure, a penalty, or an irregularity, sort of something that would prevent your ordination. You're already married or something like that, or you've committed, something else, some other thing that would make you irregular or would be an impediment to your ordination, but you present yourself anyway. This is a penalty. Now, this was a penalty under the 1917 code. Then it was eliminated in the 1983 code, and now it's the South has risen again, and this penalty is back. Some new types of penalties, fines, we already talked about. Also, for remission of penalties, for a penalty to be lifted, there can be no remission until the ordinary judges that the offender has repaired any harm that he caused or she caused. Let's see. Offenses against the Sixth Commandment by a cleric. These already were if they were offenses against a minor, already were delicts. Now there's one canon that applies to crimes against the Sixth Commandment with an adult, and another one that applies to crimes with minors. So, if Sixth Commandment, that would be a sexual crime. So it's an offense if you commit this crime, this is with an adult, in public or by force or by threats. Now it also is an offense if it's committed by abuse of your authority. You're exercising kind of a type of coercion. That's crime, Sixth Commandment commandment offense with an adult. With a child, it's just a crime under any circumstances, or with a minor. We said there's better organization, and we'll talk about that more. Now all the crimes against the sacraments are in one place. They used to be split up somewhat. And now abuse of a minor, and the Holy See really emphasized this, abuse of a minor used to be categorized as an offense against a special obligation that the cleric had. Now it's put in a category that more recognizes the gravity of the offense, and it's now called an offense against human life and dignity. So that's a good change. We're talking about the importance of structure today and of where something's located, how things are organized. This is an area where the Holy See put a lot of importance on how the crimes were organized. And now the For abortion, it's been specified that the delict is for actually procuring an abortion. There used to be some uncertainty as to whether being involved in an abortion in a more remote way uh, was brought you uh, under the penal canon, and now it's specified that the crime of abortion is for actually procuring an abortion or actually performing an abortion. It would be the same thing if you're the abortionist, and that is Canon 1397 now. Okay, that's the end of our kind of overview slash look at Pope Francis's reform, and I will see you in a little over a week. Thank you.